The appellate court, the D.C. appellate court, in an unsurprising fashion, rejected Trump's argument that he has immunity from prosecution in the J6 case. They also put an expedited timeline on his opportunity to appeal the decision to the Supreme Court. Why did they do that? Well, because they want to get this in before November. That's why. If you don't believe me, listen to what is emanating from the Obama world. Neil Cattell, who was the Solicitor General under Obama, his concern that the charges against Trump will not be adjudicated before November 6th, particularly these federal charges.
I am officially now at the freakout stage. I've resisted that for a long time, but we are now.
You don't typically freak out, so that's important.
Right. Yeah, no, I think we're now at the point, to use a different legal phrase, justice delayed is justice denied. I mean, I can't imagine a more compelling need for speed than the idea that American citizens deserve to know before the election whether a candidate for office is a felon and an insurrectionist. And it's even more galling to me because this is an easy case. There is no responsible constitutional scholar who thinks Donald Trump is right, that there's an absolute immunity, that a president can go and order Navy SEAL Team 6 to go murder his political opponent and then go and murder the senators who would try him for impeachment. That cannot possibly be right. And Judge Chutkan set a fast schedule here. And I have no idea what the Court of Appeals is doing right now. But I can tell you that I'm really worried that this delay is going to put the trial past June. It's possible that Trump will try and go to the Supreme Court after he loses on the Court of Appeals. That can take months. This is a real problem.
Do they teach turgid psychosis in law school now? Is this guy a lawyer?
They do. Well, he was the Solicitor General for the Obama administration,
yeah,
so the answer is yes.
Yes, of course.
Also, this gab session that was going on that was being moderated by Jen Psaki, former White House spokeswoman, as she's giggling about this because she's a serious person. And Andrew Weissman chimed in as well. He was one of the other attorneys on MSNBC doing his duty. Andrew Weissman, you'll remember, was the hatchet man for Mueller in the Mueller-Russian collusion investigation. Here's what he said.
Neil and I are in violent agreement on this. And to just add a little fuel to the fire, I mean, whatever judge or judges are slowing this in the D.C. circuit, it is akin to what Judge Cannon is doing in Florida. This is really not looking good for the federal judiciary in terms of their responsibility to the electorate, whether it's Judge Cannon, who has basically issued a pocket veto on that case and has really slow walked that for no apparent reason. And you have the same thing going on in the D.C. circuit. So I agree with Neil that there really is no reason for the delay. And
the delay, I mean, he has an opportunity to appeal to the Supreme Court. Jonathan Turley, George Washington University law professor, tweeting out, the D.C. Circuit Court added a wrinkle on scheduling by saying that Trump has only until February 12th to file the Supreme Court. The standard rules would allow Trump 90 days.
Why wait? Off with his head now, Dan. Put it on the pike now.
I understand, Robespierre. Thank you. If he does not file the appeal, the mandate returns to the district court, which can restart pretrial proceedings. However, if the judge restarts pretrial proceedings, it could again be interrupted by an appeal that could that includes a possible emergency motion for the court to stay proceedings. That would go to Chief Justice Roberts, and he would likely send it to the full court. If a stay were issued, we'd be back to the possible filing of an en banc decision and then a later petition to the Supreme Court and months of delay in filings alone. So this is what Weissman and Cattell are officially freaking out over, as they so loyally said. For more on this, we're pleased to be joined by Professor Richard Epstein, the James Parker Hall Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago. Professor Epstein, thank you as always.
Yes, nice to be here. I heard that. I want to tell you at the outset, There was a time long ago when Neil Katyal and I collaborated on several briefs. I think his transformation is more dramatic than mine, and I regard this case as having a rather different tone. One of the things that you note is that every time somebody wants to break down ordinary procedures in order to get something to trial, they have a collateral motive as well. And if you start to think about what's going to happen if Judge Chutkan tried this case in front of a D.C. jury, there's going to be serious doubt that she's going to get it right, that they're going to get it right. The thought that a criminal judgment coming out of that court with this particular history is going to be authoritatively definitive on the question of whether or not Trump did or did not commit these various offenses is, I think, something that is very doubtful. And one of the reasons why I want the thing to be postponed past the election is I think that it's so incendiary that it could seriously distort things. If there is a false judgment of criminality in this case that would get reversed on appeal, just imagine what would happen if in the interim the election turned the other way. Yeah. And so what they do is they seem to think about one set of horror stories that's being involved. But I can think of another set of horror stories that have been involved, because you just have to compare the speed and the absolute vengeance that this case is taking place as compared to the slow and leisurely walk with respect to any deliberation of Hunter Biden. Those are not going to happen until mañana time. Nobody's going to bring that case to trial before the election because of what it will do for beggars. And then you want to get some other information about the insurrection. Ray Epps, who was out there on the scene urging people to go into the Capitol building, got $500 in community service from the Biden administration. And so what you have to assume is that the people who are talking this way on whether it was MSNBE, are representing the pillars of justice when, in fact, the Biden administration, particularly Merrick Garland, who's its attorney general, are absolutely skewed in every conceivable thing that they start to do. I mean, it's just amazing. I have never seen a Justice Department that has been so pious on the one hand and so corrupt on the other. It's really a rather sad state for America that this kind of stuff is getting worse.
Can't we do something? Can't you do something useful, both of you? You're both lawyers, Mr. Epstein and Dan Propp.
One is a real lawyer and the other is a talk show host.
But, for example, can't you gin up or come up with some crimes that related to the border that Joe Biden and his friends have accomplished, and then try him in Waco, Texas, and put all the... Because I hear Waco is extremely conservative, and I would like to see a federal trial by jury there of these.
Look, I mean, I have the following illustration. It's a plague on both your houses.
Yes.
I think this is a political election, and to go after Biden under the same kinds of situations when he probably does have presidential immunity for official acts done when he's in service would be terrible. I don't want either of these cases to go forward. I think that the political situation is fraught enough, and the idea that a partisan prosecutor before a hostile judge in an utterly inhospitable jury technique is going to give us the truth is one of these laughable myths that happen all too often. I mean, all these guys are really very much after Trump. I want to hear somebody who's neutral say that this particular imperative works. And when you get former prosecutors who botched a lot of other cases and really went on some witch hunt, it's not so particularly terrible. You remember what they said about the Mueller hearings, which was a terrible mistake and a lot of abuse of prosecution. Poor Mr. Mueller, not only did he not write the particular indictment, he probably didn't read it, and he certainly didn't understand it. And if you'll note, he has utterly disappeared from public.
Yes.
And there's a reason for that, because massive incompetence has started to take place. And if you want to talk about crazy actions on impeachment, the first Zelenko case is an impeachable case when the president has power over foreign affairs. That was an absolute hang job. And with respect to the second case, I think, in fact, it was very much an overwrought thing. It's one of these really delicate type situations where you don't know whether Trump's rantings are protected by free speech or whether they're a source of some kind of criminal activity. The double jeopardy issue, which was not involved yesterday, is, I think, extremely important in this case. And I think Trump should win on that one, given all the circuses that went on in the first impeachment case. I think the immunity defense, as stated, is in fact wrong. But I do think that the risk that the Trump people point out, that there's going to be a witch hunt against everybody who leaves office is a very real kind of risk that you have to worry about. And so I am not particularly pleased about that. I remember my friend John Yoo, he said something in office, much of which I disagreed with. And then there were efforts to try to prosecute him afterwards, which went nowhere, but show essentially that it's going to be a pretty hard line to draw between egregious behavior that you commit in the official office and the kinds of stuff that happened here. And so that's the worry that you're about. So far, there's no sign of it going any further. We hope it keeps that way. I'm a little uneasy, I have to tell you, about using expedited dates for governing appeals. Generally speaking, we give people rights because we think they're important. And when Smith tries to invert the order and eliminate the Court of Appeals and do all of this stuff, generally speaking, when you're engaged in irregular behavior, even under extraordinary circumstances, it's dangerous because what happens is these rules are designed to protect the guilty as well as the innocent, the controversial case as well as the simple one. And what they're trying to do is to expedite the process. It's the accused who has the right to a speedy trial. There's nothing in the Constitution that gives the prosecution that option.
Excellent point, as always. The underlying substance of the Jan 6 case against Trump, what's your assessment of it?
Well, I think it's a really very, very hard case. I mean, to call this an insurrection, I always thought was absurd from beginning to end. An insurrection isn't two people getting together to try to alter the outcome of an election. It's what happened in 1861 when you had a full-scale war, and the insurrectionists were officials and military people who were in the Confederate services. We've had other kinds of insurrections. There was one right after the Spanish-American War in the Philippines, which was dealt with firmly by then President McKinley. But there you had a bunch of armed forces fighting the government, hitting in the country. There was a war. And so I don't think you're even close to insurrection land unless you have an armed force with a prolonged attack of what's going on. If election obstruction is a form of insurrection, then every activity that took place in the South during the Jim Crow era was an insurrection, and none of them were tried that way. So I regard this as crazy. I also think it's completely improper to say that the president is actually covered by the clause. He's the one who appoints the officers, and the entire structure of that clause makes it very clear that the ability of Congress to waive these things mean that you're dealing with appointed officers, not the president who's elected. And the idea that this is self-executing when a bunch of random people in 50 states can bring all sorts of action against him is not the way you run. What self-executing meant is we have passed the 14th Amendment. It says that former slaves are now citizens. You don't need legislation to do it. The act is done. It is not self-executing to have a bunch of random people go and sue, often on very dubious theories, with lots of hostile motives. The general rule that I took of the raise from the Nixon impeachment, the reason he resigned from office is that the Republicans abandoned him, and rightly so, for what he had done. But in this particular case, it's all on one side of the political aisle. Everybody on the other side of the political aisle doesn't do it. When you have red-blue impeachments in the form that you're having in this particular case, it calls the legitimacy of the entire political system into question. And I'm going to say publicly, I think the worst behavior I've ever seen on behalf of an attorney general has happened under Attorney General Garland's watch.
The case in Fulton County, just on the ethics of the prosecutor there, Fani Willis, hiring the prosecutor. The special prosecutor turns out to be her boyfriend, and now there's a dispute about whether she became her boyfriend after she hired him or it was before she hired him. There's, of course, the question about the money that she's authorized in terms of paying him for his services, but she didn't get any money except they're on vacation together. So, I mean, just so all of that. If you were presiding, would Fani Willis have to recuse herself? Would or the special prosecutor, both of them? What's your ethical distillation of that?
More serious than that. I mean, first of all, it doesn't matter when the affair began. If it began afterwards, then they have to disconnect from the case. This is not a case where Trump gets a dismissal because of prosecutorial irregularity, but what happens is they have to be removed from the case. They may well be impeached, but that's collateral. And then two things that are not noted. You cannot leave the case in the office because everything they did is tainted by everything that happened. So you have to assign it to another attorney in another county who will take over the thing from her. And the second thing has to do with work product. In these cases where there are prosecutorial irregularities, all the work product is tainted by what has happened with respect to the presiding officials. And so that has to be removed, and the whole case has to start over again. Now, I've read
well,
that.
But Professor, we can't do that because we got to get everything done before, the election, you see.
You get Weissman all upset.
Yeah.
Yeah, I mean, look, I'm not as cynical as you guys about them, but I think they're hopeless. But I think it's really that. Just sticking to this, I mean, I've been involved in cases where attorneys have been dismissed, and the whole case has to start over from the beginning. Nothing will be carried over. If she really wanted him to be put to that situation, what she should have done is kept it within the office and followed normal rules. Even contracting out this thing to somebody else is very dubious. And then when you start to see that he coordinates with the Biden administration by meeting with them in private or in some circumstances, it all has a stink associated with respect to it. And look, I mean, I will never defend what Donald Trump did on January 6th. I thought he was asinine and juvenile, but asinine and juvenile are not capital offenses in this world. They're not even criminal conduct. What they're doing is, in fact, right over the edge.
Yes,
so what you're seeing here is all sorts of very dubious maneuvers taking place to convict this man on the theory that the public has a right to know what a bogus jury is going to determine. And I think, in effect, that it's a kind of a lasting disgrace to the legal system that this stuff has started to happen. I thought the same thing about the first impeachment. I thought a little bit less confidently about the second one. I think that all of these trials should be stopped. In the double jeopardy issue, generally you could be tried only once in the federal system. A trial includes an impeachment trial, just as it includes a military trial, both done under very different rules with civil cases. And if he's acquitted there for what is associated with January 6th, that binds the whole case. So it's a very much more different kind of defense than the other one, and I think it should be there. Judge Chutkan wrote about this. I thought it was kind of a weak argument on the other side. It may well yet prevail, but it certainly has to be heard. And if my voice were to do anything, I would say you could not go ahead with this case, having once had a shot at him in a senatorial tribal. You can't bring it anywhere else. So I think there are many more obstacles that lie there. And, when they talk about justice being denied, we have the same thing about kangaroo court. So one of the problems that you have to remember is there are always two maxims that go in equal and opposite direction. You could go much too slow, justice denied. You could go much too fast, kangaroo court. And what's always typical of the Trump opponents is they assume that one kind of error is paramount and the other kind is irrelevant. If you're running a serious legal system, you have to consider both. And that seems to be beyond the capability of anybody who works on MSNBC.
Professor Richard Epstein, James Parker Hall, Distinguished Service Professor Emeritus of Law, Senior Lecturer at University of Chicago. Professor Epstein, thank you as always. Appreciate it.
My pleasure.
And Professor Epstein joined us on the Turnkey.Pro answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer.